Hello, everybody. Welcome to the final conference of the Notaries Beyond Frontiers European project. I'm Christophe Ponce, coordinator of the project. This conference is the last public event we will be organizing. Today we have 144 participants from 7 countries: Portugal, Netherlands, Belgium, Spain, Italy, United Kingdom, and France. Before I hand over to the first speaker, I would like to remind you that throughout the conference you have the possibility to ask questions in writing using the chat on the right of your screen. I'd like to thank you for your attention and hand over to Professor Olivier Artus, Rector or President of the Catholic University of Lyon.
Of work closing a very big project, Notaries Beyond Frontiers. I was told that you were working for 30 months in this project. Formation project for notaries about the new European rules 2016-1103 and 2016-1104. And so I was told also that you had 10 workshops linking different nations: France and Italy, France and Portugal, France and Belgium, France and Netherlands, and France and Spain. And then you realized the guide in 5 languages dedicated to the notaries with 15 practical cases, and also 6 kits were written during this period of 30 months. And finally, formation kits also in the 5 languages of the project. So I have to thank first the law school of the Lyon Catholic University and its dean, Professor Michel Canarsa. And we had nice partnerships in the context of this project, and particularly I will quote in French this time because I have the list in French on my document. I will quote
Notarial Centre for European Law, the Order of Notaries of Portugal, the International Council of Belgian Notaries, and the Royal Dutch Association of Civil Law Notaries, and the Spanish College of Notaries, and the Chamber of Notaries of Milan.
There was a co-financement of the project, and I have to thank here the European Commission for its involvement in this project, and this involvement allowed finally the project carried out. So now I know that you have an afternoon of work till 6 p.m. I was told, so I wish you a very nice work together to close finally a nice project that was accompanied by our law school. And once again, all my thanks to the dean of this faculty, Professor Canarsa. Thank you so much.
Thank you, Rector. So I note that Lyon Catholic University is very interested in developing innovative projects in Europe and internationally, and we're lucky enough today to have the participation of Mrs. Voutravers. I see that she is connected, so we're going to move straight on to the next part of our presentation. So we have Marie Voutravers, Policy Officer at the Directorate General for Justice and Consumers at the European Commission, and she is going to present the legislative and financial priorities of the European Commission in civil and commercial matters for the period 2021 to 2027. So thank you for accepting our invitation to be with us here today. If you could now ask to speak, and that way I'll be able to hand over the floor to you. So I'm now going to hand over to Marie. As I think you can hear me. I hope you can hear me. I see myself on the screen. I had a few difficulties logging in. So hello, everybody. I wish you all a good afternoon. I'm delighted to be speaking to you today, even if it is from a long way away. It's always a pleasure to take part in European projects with participants, including notaries like yourselves. I have prepared a PowerPoint presentation, if I can find it. It's now on the screen. I'd like to begin by introducing myself. Marie Vautraverse. I'm a judge. Many years ago, I was a judge for family affairs and also dealing with minors at the court in Évreux and in Nanterre. For a few years after that, I worked at the permanent office of The Hague on the iSupport project on maintenance obligations and collection of sums from abroad. I was deputy to the head of the office for civil mutual assistance, that's the Ministry for Justice in France after that, working with the European Judicial Network, and in that context I worked a lot with French notaries and also from other countries in the EU. And now for a little over a year I have been working at the Unit for Civil Justice as the Directorate General for Justice and Consumers at the European Commission, and I am an international expert for at least the next few months or perhaps for a few more years. So I'm going to give a brief and general introduction of the priorities of this new term of office of the European Commission in civil and commercial matters, both the aspects of legislation and also the available funding or grants. If we could move on to the next slide. So this term of office of the Commission began in 2019 under its President Ursula von der Leyen and her new team of commissioners. The Commission has adopted a certain number of general priorities, which I have noted down. The most important are the Green Deal, of course, that's one that many people are familiar with. The second is a Europe adapted to the digital era. That also is of importance in judicial matters and in civil and commercial matters. The third priority is an economy at the service of European citizens. The fourth is a stronger Europe internationally. The fifth is promoting our European way of life, and it's part of this priority that we find the priorities in judicial cooperation. And finally, a new impetus for democracy within the European Union. So the Commissioner for Justice, Mr. Didier Reynders, who is of Belgian nationality, received a mandate from the President with a certain number of objectives to be achieved during his term of office. And here on the slide you have the two main objectives which are of interest to us here: to facilitate judicial cooperation between Member States and develop the judicial area. This isn't a new initiative. We've been working on this for some 20 years now, developing this little by little, but to try to reinforce this judicial cooperation and to foster effective use of new technologies to improve the effectiveness and operation of our justice systems. If we could move on to the next slide, please. So in legislative matters, I'm going to begin by the digitalization of judicial cooperation. You have seen that from the beginning of the term of office in 2019, this was a priority for the Commissioner for Justice. And as everybody knows, this priority has been accelerated by the COVID crisis that we have been through, are still going through, especially when there was the lockdown last March, where we realized that the judicial systems were not necessarily sufficiently digitalized and were having difficulty operating, whereas in some member states, notably Estonia, which had totally digitized their judicial system, their activity could continue without too much difficulty. So this also is of concern for judicial cooperation, even if the central authorities and the competent authorities, the notaries, the notice servers, the courts have tried or did try to work on their judicial cooperation on the most urgent cases. It was difficult, And therefore this accentuated the interest of the European Commission in finding ways of digitizing judicial systems in the different member states as much as possible. So this isn't a new initiative, as I said. This began, in fact, a few years ago through two regulations you may have heard about, which were renegotiated recently with a recasting of them in 2020. So the regulations on service of documents and the regulation on taking of evidence. These two regulations dated from 2001 and 2007, respectively, and have now been recast with a number of modifications which have been made, notably concerning the obligation for the competent authorities pursuant to these regulations to communicate by electronic means. These regulations will come into force in July 2022, and the electronic communication will probably only come into force in 2024 or 2025, but by that date, it will be mandatory. All the courts, all the notice servers, all the different authorities which must apply for evidence or who want to hear a witness, it will be mandatory to use electronic means. There will no longer be any paper applications possible. So this initiative is the first in this area. Today the Commission would also like to digitize the whole of judicial cooperation in civil and commercial matters. It's an initiative which is already well underway. There has been a communication published on this subject, that was last December, which you will find easily on internet, and I will send you the links for that. And there's currently a consultation which is underway in which you can all take part to try to collect the opinions of all the practitioners and all the competent authorities and from the general public regarding this aim to digitize cooperation in civil and commercial matters. So that's regarding digitalization of judicial cooperation. Another legislative priority of the Commission for this new term regards the protection of vulnerable adults. This is a subject, once again, which has been of interest to the Commission for quite some time. You perhaps know that the Hague Convention of 2000, which came into force in 2009, has only been ratified by 10 European states, and that establishes rules of private international law determining the applicable law, and to organize the circulation of protection measures for vulnerable adults in the European Union. And unfortunately, it is not applicable throughout the European Union at present, which does cause great disparities for these adults who are protected and who might have bank accounts abroad, who may need to travel abroad, who may need medical treatment in another country. And in all these cross-border situations, the situation at present in Europe is not harmonized. The Commission has encouraged the Member States to ratify the Hague Convention. The European Parliament has done so as well on many occasions. Unfortunately, 12 years on, the situation is still not satisfactory. So the Commission has decided to assess whether legislation is required in this area. A legal study was undertaken or begun last month. That report will be ready in November of this year. And a lot of consultations will be organized for that study. There's also the Green Paper on Aging, which was published in January, which is also organizing a consultation on the action to be taken by the European Union in response to aging of the population. And there are references there also to the question of vulnerable adults. And so anyone who is interested in these questions can give their opinion in the consultation. it's possible that there may be a new regulation or a decision of the Council forcing the Member States to ratify the Hague Convention of 2000 at the end of 2021 or in 2022. But of course, no decision has been made on that subject for the moment. That's just a possibility. Regarding the recognition of parentage, this is an initiative of the President, Ursula von der Leyen, in her last speech on the State of the Union, where she said that she wanted that when somebody is a parent in one country of the European Union, they should be a parent in all the countries of the European Union. So this raises the question of recognition of parentage between member states. At present, there is no instrument at European or international level, because this is also a question which is being discussed at the Hague Conference on Private International Law, and this causes a lot of problems for families. There are ties of parentage which have been established, recognized in one member state, but which are not recognized in other member states, which gives rise to a lot of complaints. We know that there are very practical difficulties in this area. So that is also currently being evaluated to assess the needs and to see what initiatives might be possible, which might lead, if possible, obviously this is a very sensitive subject, but it might lead to a new regulation in 2022. The big priority of the Commission at international level is the Hague Convention of 2019 on judgments, the Hague Judgments Convention. You know that this convention was negotiated through the Hague Conference in Private International Law, and it makes provision for the organisation and enforcement of decisions in civil and commercial matters at worldwide level. It has just been adopted, it hasn't yet come into force, and the European Union would like to be able to ratify this convention on behalf of all the member states. A proposal of the Commission should be made, published very soon, very probably in the second half of 2021, for a decision of the Council to authorize the Union to ratify that convention. And the last priority in legislative matters concerns the harmonization of insolvency rules. There are already a number of instruments governing insolvency matters and liquidation of undertakings, but the European Commission is considering, once again, there isn't yet a proposal to this effect, it is just a possibility and a priority. The European Commission is considering harmonizing the substantial rules in the member states on non-banking insolvency, and there is a study currently underway on that subject. So that's the outlines of the legislative priorities. So on the next slide, the priorities do not just involve adopting new instruments. You know, we already have 21 regulations and directives in commercial and civil matters. So the idea isn't just to adopt a new text, but also to assess the existing texts which are already in force to see whether they need revising. Among the instruments which are on the table for evaluation are the recasting of Brussels I, the Rome II regulation on the law applicable to non-contractual rules, and then also the European Enforcement Order, and a report will be disclosed on that in the course of 2021 on the implementation of that regulation. There have already been a certain number of consultations on that subject. Also, we need to transpose the directives which have been adopted. For example, the directive on restructuring and insolvency, which had a transposal deadline through to July 2021, which has been delayed by most of the member states, which have been having difficulties. That's now July 2022. Another very important instrument in family matters in particular, which requires the involvement of notaries. That's the Brussels 2 bis recast, which should come into force in August 2022, so not straight away, but it's not as far away as all that. The member states, the Commission has already asked the member states to publish all the information provided by Article 103 of that regulation, and notably the list of the competent authorities to certify decisions, because you know that in this regulation it abolishes the exequatur process in family matters, and this was a request of France, among others. It allows the recognition of out-of-court divorces in the rest of the European Union. So these divorces have to be certified so they can then circulate throughout the European Union. This is a question which is currently being worked on by the different professions, because divorces registered by a lawyer or a notary could be certified by the notary, by the lawyer, by a judge, and the authority which is charged with that certification will have to check that the decision complies with the interests of the children, which is an additional requirement. We can perhaps move on to the next slide now. As I said earlier, we have a lot of instruments to be implemented by the different judicial and legal professionals today, and the European Commission also has a priority consisting in making sure that these instruments are properly implemented, that they need, especially when they have to apply these instruments on an occasional basis and they're not necessarily familiar with them. In this respect, the European Judicial Network in Civil and Commercial Matters is still receiving support from the European Commission, which serves as its secretariat. We'll see later in the funding that there is also particular funding for that. We shouldn't forget that all the judicial professions in Europe are included, and it really can provide all practitioners having to deal with a cross-border case immediate answers on the application of EU law. The e-Justice portal also continues to be supported by the European Commission. It contains information sheets on national law, also on the implementation of the European instruments in each of the member states. For example, the regulations on matrimonial property regimes and registered partnerships, the European Atlas with information sheets on that to know which is the competent authority for a declaration of enforceability. For example, don't forget either the e-Justice portal, which has lots of information when you have to deal with a cross-border case. Finally, and to finish with these legislative and non-legislative priorities, to mention the new strategy for judicial training in Europe, which was just adopted for the 4 coming years, if I remember correctly, and which intends to extend judicial training in Europe, not only to judges and prosecutors, who were the main targets of the strategy hitherto in Europe, but also to all the professions, including court registrars, lawyers, of course notaries too are included. They are one of the priority targets. They already take part very extensively in the training activities at European level, and the objective is to get the percentage of notaries taking part in that training up to 30% within the next 4 years. If we can move on to the next slide. And the next slide. So I am now going to talk to you quickly about the priorities in terms of grants and funding offered by the European Commission. And I'm going to focus on the call for projects which was just published by my colleagues and which is for the coming year. So just to remind you generally what the objectives are, on what grounds can an association or an authority make an application for funding for a project from the European Commission. The idea is to distribute that funding so as to enable the European Union policies that are adopted in Brussels by the member states and by the European institutions to produce tangible results in the field in all the member states and in a manner that corresponds to the real needs of practitioners. The aim is also to improve judicial systems within the European Union and improve respect for fundamental rights. Also, these are the three general objectives of this funding granted by the European Commission. If we can move on to the next slide. So, among the three calls for projects that might be of interest to you, the first concerns projects relating to e-justice. These projects, on the slides here, I haven't gone into too much detail. If you want more detail than what is on the slide about the criteria for these projects, at the end of the presentation you will find a link to the platforms where you can get all that information about the project. So the e-justice projects must be developed at European level or national level, provided that if they are at national level they should still have a European dimension. They can serve to facilitate cross-border communication, notably via video conference, to improve the interoperability of video conference systems. They can also finance projects to integrate multilingual forms within the framework of the regulation on public documents, which states that a certain number of public and notarized documents no longer need an apostille or legalization or even a translation, provided that they are accompanied by multilingual forms. These multilingual forms are already available on the e-justice portal, but each authority can also integrate them into its own system so that they can be generated at the same time as their own public documents, and the Commission can finance that in the national systems. E-justice projects can also concern participation in e-codex projects. What is e-codex? E-codex, to put it simply, in the extreme, is the pipe through which the communication passes between national systems, electronic communication between national systems. So to be linked to e-codex will probably become increasingly necessary in the coming years, because it will be those pipes that will be used for judicial cooperation when it becomes necessarily electronic. So for the regulations on the service of documents or on evidence taking, the authorities will have to abandon paper documents and just use electronic means in the future, and notice servers and courts will have to use this tool, this e-codex tool, and connect their systems into it. And these projects and any projects linked to e-codex can be financed by the European Commission. Then there is taking part in search engines available on the e-justice portal and elsewhere to enable people to find the competent authorities in Europe. That can also be financed. And then there are search engines such as Find a Notary, which are available on the e-justice portal. And finally, any project relating to participation in the sorry, I've just noticed there are some spelling mistakes in my slide. I prepared it a bit too quickly, so I apologize for that. So taking part in the court database, what is the court database? It is, as its name suggests, a database which lists all the competent authorities within the European Union with their contact details, and which enables you in the e-justice portal to find a notice server, a court, a competent authority within the European Union for each instrument, and it also enables you to fill out automatically the forms which are generated, on the e-justice portal with all the contact details of all the courts and competent authorities. So now we're going to move on to the next slide. So the second call for projects which might be of interest to you is the call for projects on judicial cooperation in civil matters and also criminal matters, but here I'll focus on the civil side. These projects must support the following priorities: either the better enforcement of decisions of the courts, any projects related to enforcement, and the recognition and enforcement of decisions can receive financing. The regulation of 2009 on maintenance obligations. So these projects could also the recognition of the civil status of children within the European Union, linked to the initiatives on the recognition of parentage. And all these different projects, these can receive funding. Other procedures can also receive funding if they relate to succession, to the circulation of public documents, serving of documents, or taking of evidence. And when I talk about the circulation of public documents, that's regarding the European regulation which did away with legalization and the apostille for certain documents. And finally, the Commission continues to support the European judicial networks, the national networks, and France has already, and I think there will be others in the coming years. So if we can move on to the next slide, we're reaching the end. The final priority regarding the funding is judicial training. Any project relating to the training of judicial justice professionals can receive funding. Multipliers or relay who might disseminate European law in order to make sure that the law is disseminated exponentially. So also local coordinators for union law who will be present in the courts and will train their colleagues in European Union law. And finally, projects for interprofessional training will be encouraged. The idea here being not to restrict ourselves to one or two professions or just to the courts, but really to cover involved in implementing European Union law and fostering better communication, better cooperation between them. So these are the practical details. So the deadline for submitting projects and funding applications is the 6th of May. The platform for submitting the project should have been open 2 weeks ago. I've been told there's been a few technical problems. It should be opening just sometime around now. And there you have the different budgets for the different categories of projects. And we hope that we will reach the objectives which have been set. And if we could move on to the next slide. So I have just indicated here 2 useful links which were mentioned during my presentation. But of course, if you have any questions, feel free to contact me and I will be delighted to refer you to my colleagues who deal with these questions of training, funding, or the legislative questions. I hope I haven't gone on too long. I have finished my presentation, and if there are any questions, I would be delighted to answer them.
Thank you very much, Marie, for talking to us about the priorities of the Commission for the new mandate in civil and commercial matters. Certainly, be able to respond with new projects. And the time has now come to have a general overview of the work done within Notaries Without Frontiers, and I would just start with a short retrospective video of the highlights of our project.
There you have it. So you saw the highlights of the MBF workshops, but MBF was not just about workshops. So now we are going to give you some feedback on the activities carried out within the MBF project, and I'm just going to present a short summary. Now, first of all, MBF was part of a political context. In 2017, every year the European Commission publishes a work program in which you have the priorities both at legislative level and at financial level of the European Commission. And in 2017, among the priorities, we had the objective of contributing to good implementation of family law instruments in light of the importance of the topics that are addressed there for the daily lives of EU citizens. And in there was a desire to anticipate the entry into force of regulations 2016/1103 and 2016/1104. And to anticipate that, the European Commission published a call for projects, and the previous speaker mentioned that to us. She talked about the current call for projects, and we presented a project in the framework of the previous call in 2017 with a view to anticipating the implementation of regulations 1103 and 1104. And this call for projects aimed to fund transnational cross-border projects to promote judicial cooperation in civil and criminal matters. And among the eligible activities, we had reinforcement of the capacities and abilities of professionals, exchange of good practice, mutual learning, and then action intended to disseminate and raise awareness. And to be eligible, we had to involve organizations from at least 2 eligible countries and request a subsidy to an amount higher than 75,000 euros. So you wanted a critical mass there to have projects with genuine impact. The Commission also expected some outcomes, in particular an increased capacity of national practitioners and authorities to address issues related to judicial cooperation in civil and criminal matters. It also wanted the projects to allow enhanced knowledge of legislation and administrative practices related to judicial cooperation in civil and criminal matters, and it wanted acceleration of procedures related to these forms of cooperation, so fewer cases of not meeting timeframes. Now, based on those specifications, we defined the Notaries Beyond Borders project. Now, what are the main features? First of all, the project brought together three partners: the Université Catholique, Catholic University in Lyon, the Centre Notariat du Droit Européen, and the Portuguese Ordem dos Notarios, and four associate partners: the Belgian Council, the Spanish Chamber of Notaries, the Milan Chamber of Notaries, and the Royal Dutch Association of Civil Law Notaries. It lasted for 30 months, from October 2018 to March 2021, and the maximum subsidy that we could receive was 227,848 euros, i.e. 80% of the project cost. Notaries Beyond Frontiers organized in 4 groups of activities. We call these work packages. The core issue was the groups of activities you can see there in blue on the screen. And the first was to identify the specific training needs for notaries, and based on those needs to create modules. Then with these modules, or thanks to these modules, the idea was to train, to improve the capacity of notaries regarding regulations 2016/1103 and 1104. That's why we organized webinars and training sessions. And then around these workshops, the life of the project, we disseminated, we communicated as much as we could with the notary professions, but also with the public at large. So what were our main organized events or achievements? Well, I would say that the first was the organization of 10 bilateral workshops, 3 between France and Italy, in Lyon, Milan, and one that was supposed to take place in Venice, but because of the COVID crisis, it was online. Then we had 2 between Franco-Portuguese workshops, 2 Franco-Dutch workshops, 2 Franco-Belgian workshops, and 1 Franco-Spanish workshop that was supposed to take place in Valencia. Again, due to the health crisis, we had to organize it in a decentralized way. So, beyond the actual workshops, MBF organized 2 learning consolidation webinars. So beyond the workshops, we had webinars that came back to the issues that came up during the workshops and perhaps hadn't received a complete answer. So we looked into them in greater depth during these webinars. Other achievements was the creation of training modules in each language of the project. So you've got modules presenting regulations 2016/1103 and 1104. Then you have the matrimonial property regimes presented, those that apply in Spain, Portugal, Spain, Italy, Belgium, and the Netherlands. You had training modules regarding the rules regarding competency, jurisdiction, recognition and enforcement of decisions, as well as acceptance and enforcement of notarial instruments in France, Portugal, Spain, Italy, Belgium, and the Netherlands. And there was an entire section addressing binational case studies or binational practical cases, where we sought to answer practical questions notaries were asking. Other outcomes or achievements were the creation of a booklet which brings together the 15 most iconic, emblematic, or relevant binational cases. We also created 6 national data sheets presenting the matrimonial property regimes of the member countries, the partner countries. And we created a document, a leaflet for notary clientele. We also carried out an impact study, first of all to check the benefit of the projects with the notaries who participated, but also to measure to what extent the regulations are now understood and learned, and what are the problems or issues that are still arising. And based on this impact study and based on the workshops and all the activities in the project, we drew up conclusions and recommendations that will be presented to you a little bit later. Of course, we also created a website that will allow you to find all the documents, all the materials that we prepared in the framework of the project, and you can also ask questions. There's a question and answer service where you can receive answers. And finally, among the main achievements of this project, what I was talking about earlier is the dissemination and communication campaign, in particular with consulates and embassies of the cities that welcomed MBF workshops, but also to the press. European project is organized as activities, but also as deliverables and as outcomes. So I just wanted to explain to you these deliverables. There were 35 deliverables. For the 31st of March 2021, we will have delivered 35 deliverables. 341 people answered the inventory of training needs, with a very strong participation on the part of Italian notaries. Also, 476 people attended the 10 MBF workshops, and there was a strong mobilization for the workshops in Portugal, in Porto and Lisbon, very significant presence of the Portuguese notaries. The profile of the participants at the notaries, well, no surprises there, mostly notaries. We also had student notaries, trainee notaries, but there was also a specialization strategy on the part of a number of notaries, because I saw that 8 French notaries attended at least 4 workshops, binational workshops. Other deliverables and results and outcomes is 106 dissemination and communication actions through the websites of the partners, on the social media, the awareness campaign with consulates and embassies in the countries that participated in MBF, and distribution of member state data sheets and international couple brochures during the workshops. As I have said, we will present our conclusions and recommendations at MBF level at 5 p.m. today. Finally, there are links that you can use to get all the MBF documents, the modules, the presentations, everything you would like to see that is related to the project, and all of this is available on our website. Thank you very much for your attention. We will now come to the crux of the matter with a panel. The theme of the panel is the regulations 2016/1103 and 2016/1104. The theme is, what are the difficulties? I will leave the floor to Professor Cyril Nourissa, who is from Jean Moulin University, Lyon 3, and with him in the panel we will have 4 notaries: Francesca Castro, who is a notary in Cascais in Portugal. She's also the vice president of the Notaries Order in Portugal. Hugo Friedman, who is a notary in Milan. Monique Rombouts, who's a notary in Zundert in the Netherlands. And Frédéric Varin, who's a notary in Distre in France. And I would particularly like to thank these 4 notaries because they have been very active throughout the MBF project. Thank you. Thank you very much, Christophe. Is this working? Yes. All right. Well, the advantage of working with Christophe is that, in fact, he does your work for you in advance, because he's already announced the purpose of this panel, this roundtable. He's already announced the participant speakers, and so I can go through what I had to say very quickly to leave more time to allow Francisca, Ugo, Monique, and Frederick to speak. So the theme of this panel, number one, is the difficulties, in fact, difficulties in implementation of EU regulations 2016/1103 and 2016/1104. And if we all agree, we will first of all focus on the difficulties encountered regarding 1103, which is the regulation on the applicable regime. And perhaps a question, first of all, to each of you. Namely, what difficulties, spontaneously, what difficulties do you see in the implementation of these regulations? Although I know you're all now experts in this regulation, and I'm sure you've managed to overcome the difficulties and hurdles, but I will leave the floor now to the different speakers. I think you have to ask Christophe to allow you to speak, I think, and then he will leave you the floor, if I understood how it works. Yes, so Francisca, if you would like to speak. Oh, sorry, it's Monique, all right. Yes, thank you, Christophe. Can you hear me well? Can you all hear me okay? Yes, hello. I'm going to quickly going to go through some practical points that I felt were important reading the regulation. The issue relating the relative form on choice of applicable law in Articles 23 and 25 are not practical if one of the future spouses lives outside the EU and one lives in the Netherlands. The additional formal requirement is regarding application in the Netherlands is the notarial instrument in the Netherlands if the spouse who lives outside the European Union cannot travel to the Netherlands. We would then have to use a power of attorney, the matrimonial convention agreement contract, and the application can be done only in the Netherlands, and the principle of lex loci does not apply supposing that the other future spouse lives in the United States, for example. It would not be possible to enter into a valid prenuptial agreement in compliance with the law that applies in the US. The current health crisis linked to the coronavirus makes travel difficult, but in cases like this one, this is really not convenient. If you compare it with the 1978 Convention on Matrimonial Regimes, it is stipulated in Articles 12 and 13 that to be valid, the form of matrimonial agreements and designation of internal law, or with the domestic law of the law of the marriage. With the agreement to declare a marriage agreement as non-valid, there is a greater risk that the agreement would be challenged. That was one of the difficulties that I encountered. Yes, thank you very much, Monique, for those observations, which is a difficulty, of course, linked to the crisis. But regarding matrimonial regulation involves a number of difficulties and opens up quite a few problems. The problem of the form of the choice of law agreement is a problem that I had noted myself. And secondly, you have to consider that these regulations are regulations that find their starting point on the 29th of January 2019. And in that regard, we have coexisting regimes, regimes that regarding property that applied before, and the regimes that are regulated by these regulations. So it means we still have to do, from my viewpoint, a lot of work regarding dissemination of the information. Questionnaires were often useful. I apologize if my French is not very good, says the speaker. This dissemination of information is very important because the fact that we have changed the criteria regarding the property regimes, the fact that that changed in 2019 gives rise to a number of questions for notaries like me, who are used to reasoning on in European private international law, Italian private international law. So the fact that you have criteria like the habitual residence that the two spouses chose after the marriage, these are criteria that are not easy to intercept, as it were, either through the very notion of habitual residence, and it's not today that we're going to talk about that, but it's also to, in practical terms, understand what is the common habitual residence after the marriage. And what we have to consider is after the marriage, taking into consideration whereas clause 2, which tells you that it's a brief period, in that recital it says a brief period, but what is that? Is that 4 months, 6 months? What does that mean? And today as well, the spouses can choose a common matrimonial property regime, but can also change the previous regime, and can do that retroactively as well, except with the binding of third parties regarding what they're going to do. But they also, from a tax viewpoint, there are issues. As you know, the succession regulation or the matrimonial property regulation doesn't take taxation aspects into account, but the consequences of a choice made simply from the viewpoint of civil law can also have consequences under tax law. The problem of publication as well, and opposability, so binding of third parties in particular, these are points that can make things more complicated, make them not immediate, and make them not very simple to apply in terms of European legislation. And the problem which we have seen, but today that we have not yet solved, regarding the tacit choice. The tacit choice which is accepted in the succession regulation, but which is challenged in the regulation on the regimes. And our colleague, Professor Nourissa, has several times, raised this issue. And when it comes to applying this new legislation in the system of each of our different countries, it's not so easy to manage all of this. Here, of course, what I would like to say is information, dissemination, trying to the greatest possible extent to do a good job. And I believe that with this project, we have done a good job. I've followed this project with great enthusiasm and supported it. And today I am still trying to enthusiastically support and follow the project, and I hope that we will have new applications. We have tried to work here in Italy through our national council, and it's never enough, really, because these are things that are not immediate. They are not instinctive to understand and to apply by judicial operators in each country and legal practitioners in each of the countries. That was the first impression. And those are just my first impressions, but perhaps I'll speak again a little bit later. Thank you. Thank you. Thank you, Ugo, for those first observations, those first difficulties reported, and the issues of application over time, the issue, even material application of the regulation, what falls within the scope of the regulation and what does not. And these are issues that we will be able to address subsequently in the exchange of views that we will have. I'll now leave the floor to Francesca. Hello? 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 Can you hear me? I'm very sorry. The speaker, the voice of the speaker is sped up, and I cannot hear. I'm very sorry, but the speaker's voice is sped up. It's. I hope that you can hear me. If you can't hear me, please let me know. Yes, there would appear to be a communication problem. Your voice is distorted. It's totally sped up, as if. So perhaps while we are trying to sort out this technical issue, wait, let's see. Are we okay now? Can you hear me now? Can you hear me now? Sorry, there is a difficulty there because the voice is very fast. It's sped up like So maybe let's just hear from Frédéric Varin. Hello, everybody. I hope that I don't have a voice. It sounded like a helium balloon voice, like Francisca. No, can you hear me? Can you hear me well? Yes. I would like to thank Christophe and Marjorie for the organization of this event, this final conference, which I believe is very important. So thank you very much there. From what I understood from my two colleagues, Monique and Hugo, we realize that these regulations on matrimonial regimes and on property consequences do pose some problems related to their scope of application. So what is the subject matter scope, and also in geographical terms when you're faced with third states, and also the scope of application in time. So when you have situations that, you have to consider from what date you are considering the situation of the couples. I would like to come back to this issue and focus on the issue of reconciling these two regulations, 2016/1103 and /1104, and how do we reconcile that with the other European regulations and other international regulations? Article 62 of these two regulations is talking about reconciliation of this regulation with existing international agreements. But as a matter of consistency, we should not be adding regulations to the conflict of laws that wish to solve. Article 75 of another European regulation, which is the succession regulation, refers to these possible conciliation clauses on the subject. In regulations 1103 and 1104, Article 62 of both regulations on the property consequences and on matrimonial regimes indicates that the regulation does not have any incidence on the application of bilateral or multilateral agreements to which two or several member states are parties when this regulation is adopted, which concerns the subject matter of this regulation without prejudice to the provisions adopted by the member states pursuant to the treaty. Now, notwithstanding paragraph 1, this regulation applies among member states on agreements that address issues which are discussed in the subject matter hereof, to which the member states are parties. And then there are, in the third point, various conventions and agreements between, in particular, the Nordic states, Norway, Sweden, Denmark, and Iceland. So regarding France in particular, what specific case do we have here? France, we have a we have a French convention that was signed in April 1967 and a Yugoslav agreement signed in 1971, and we have the Hague Convention of the 14th of March 1978. And this last convention, which is the Hague Convention of 1978, applies between France, Luxembourg, and the Netherlands to the spouses who are married since September 1991. Paragraph 2 of Article 2 of Regulation 1103 or 1104 stipulates that notwithstanding paragraph 1, the regulation prevails. So what does this mean? It means that if Poland had participated in the reinforced cooperation, because it's not in the 18 who adopted this regulation, the regulation would prevail over the Franco-Polish agreement. For the time being, Poland does not have the intention to adopt the regulation, so the problem here is solved due to that. We have none of the states of former Yugoslavia who are part of the reinforced cooperation, so that means these conventions, agreements would prevail. And then we have the specific case of the Hague Convention, which I mentioned. The Hague Convention will no longer apply in France, Luxembourg, and the Netherlands to determine the matrimonial property regime insofar as we are beyond the date of the 29th of January 2019. So now that's the case. We no longer apply the Hague Convention. So spouses married between the 1st of September 1992 and the 28th of January 2019 will remain subject to the Hague Convention, but this should be subject to the transitional provisions which are stipulated in the matrimonial property regulation, which says that Chapter 3 applies only to spouses who are married and or who designated the applicable law after the 29th of January 2019. So these new conflict of laws regulation in terms of determination of matrimonial property regimes will apply to spouses only as from the 29th of January 2019. Now, all of this leads us for certain decisions to have to make choices, or if you spouses married before that date, in order to choose an applicable law for their matrimonial property regime or change the law as from the 29th of January 2019, will have to be subject to the more restrictive provisions of the regulation, In particular, they will no longer be able to subject real estate property to the law of the location of the buildings in compliance with the unity of law principle in the regulation. There is an issue regarding automatic transmissibility of attachment is removed by the matrimonial property regime regulation. So spouses married between the two dates 1992 and 2019 will continue in the framework of the objective attachment, or when they have not referred or chosen an applicable law, they will be subject to the Article 7 of the Hague Convention provision. So now there is a need to articulate or to express all those rules. So that is what I wanted to say regarding the difficulties that we have encountered so far. And maybe if I speak again later, I will refer to some of the recommendations we could make to fellow practitioners. Thank you, Frédéric, for those observations. And we have noted that in the same thing as Ugo said in SAD is in fact an issue of application over time. Now I suggest that perhaps we try again to leave the floor to Francesca.
Can you hear me any better? Is that okay? I think, I don't know if there's something that we can, do for Francesca. I think there is perhaps a bandwidth problem there or something. Perhaps, I don't know if you could try on her telephone, that might be a possibility. In that case, while we're trying to sort that out, I'll perhaps make a couple of comments, and as our three speakers suggested, I will perhaps hand back to them. We see that in the first subjects brought up by Monique, there's the question of universality. In what Ugo and Frédéric said, there's the question of application over time. And in the difficulties raised by Ugo is the question of the material application of the regulation. The first thing I see here is that ultimately our Dutch, Italian and French notaries have identical comments on the difficulties of implementation of the regulations. That might be a bit deceptive, but I think that is an important point because it does show that there is a common awareness, a common reality, a common culture ultimately in the implementation of the regulation. Obviously, the text can always be improved, and we can perhaps come back to that later in the day's proceedings, but we do see here that notaries around Europe in the different member states who have taken part in the NBF program have identified these difficulties which they may encounter and the same type of difficulties that they're encountering. So Ugo and Frédéric had other difficulties that they wanted to mention. So and also if Monique would like to add anything, would like to step in, so I suggest to hand back to them. So if you could ask to speak, I will hand the floor back to Mr. Ponce, will hand the floor back to you. Thank you to allow me to speak again. I just wanted to ask a question of Monique and Ugo, whether their countries, the Netherlands and Italy, have bilateral agreements, conventions, what the situation is, and what impact that has on their professional practice. Ugo, would you like to speak? Okay, thank you. I would like to say that very sincerely. I can't give you a full answer on the existence of these bilateral conventions and their impact on relations with other countries. In my professional life, I have never had the opportunity to address any such conventions, and so far, until today, I haven't checked whether there are any. Perhaps Paolo later could pick up on this subject because he perhaps has more extensive experience than I do in this area. So I wouldn't like to say anything that might not be correct about whether there are any such conventions, and Paolo perhaps can mention that later, and about whether they might enter into conflict with the regulation. So we have our law, a law on private international law, which does cover this. But if we're talking about bilateral conventions, I really am sorry, but I do not know what the answer is. I can't answer on that question, so I will hand back to you, or perhaps if Monique would like to speak for the Netherlands.
Just like France, in Holland we have the Hague Convention of 1978 that's applicable on the marriages from 92 till 2019. So we have a lot of different rules because before the Hague Convention we had jurisprudency regarding the subject. So at this moment we have two conventions, 2019 and the Hague Convention of 1978.
Bien, merci beaucoup.
Thank you to both of you. So we see here that the question of application of the regulation over time is certainly a point to be watched with vigilance when it comes to the implementation of the regulation. And it's a question which is largely dependent on the legacy, the existing situation in each of our countries. We see that in France and in the Netherlands, as Frédéric and Monique have said, there is the precedent of the Hague Convention. The situation is different in Italy, and this means we do have to be careful regarding this question of application over time. I don't know if technically it is possible to hand over to Francisca, but there's also the question of the material application, the substantial application of the regulation, and the matters covered by the regulation or not, leaving aside the taxation question. But among the subjects covered by the regulation, there's the question of the interpretation and the application of certain central notions of the regulation which has been raised. The choice of law, the last residence. So on those subjects, perhaps too, we could hand over to our four notaries, hopefully, to see how they address these difficulties today in characterizing, defining the habitual residence of the spouses as a way of choosing the applicable law to the property regime. Would they like to share their ideas briefly on that? Thank you very much. I suggest that we begin with Mr. Varin, if he would like to ask to speak. this notion of a common residence. I think the regulation doesn't give a definition, if I remember correctly. So we have to be careful when determining this common residence. I'll hand over in a moment to my colleagues on this subject and perhaps come back to this later. But I think we also have to bear in mind this notion of residence, which is important, common residence, or what we see in the habitual residence, which is the term used in the regulation on matrimonial property regimes. We have to be careful not to confuse these different notions of residence. There's also a notion of home address of domicile, tax residence as well. So in each area, in each regulation, even when we're using the same words, habitual residence, for example, it's an autonomous notion. We don't transpose this concept, this notion, from the successions regulation, where there might be certain elements in the whereas clauses at the beginning of the regulation to guide this determination, but it won't be exactly the same method to determine the habitual residence regarding the matrimonial property regimes, because the notions are autonomous here. Similarly, if the European Court of Justice gives a definition one day in succession matters, we won't be able to apply that to matrimonial property regimes. And for the moment, I'll hand over to my colleagues if they would like to speak. I agree with what Frédéric said, and it's precisely for that reason that I raised this problem of the application of the substance of the regulation, because we have had quite a lot of problems regarding habitual residence in the succession regulation, where we were used to applying certain criteria which perhaps are not the same. In some cases, which might be closer to the English notion of domicile or home address. And with the different concepts here that need to be addressed to determine which is the most important criterion in choosing that habitual residence, in determining that habitual residence. And we don't have the same concept of habitual residence, which is different from the one we were used to working with previously. So this adds complexity to the handling of these regulations. So on that subject, I would agree with Frédéric. I would like, if possible, if we could have the same criterion for habitual residence, at least for the regulations on succession and matrimonial property regimes, that would be great. But that's not the way it is for the moment. And each time we have to be careful, pay attention to determining this. But that is an aspect which I think could be an immediate difficulty, a practical difficulty for us when we are determining the applicable law. Thank you, and I'll hand over to Monique, or perhaps to Francisca, if she can now speak. Okay, so it would seem that we might have Francisca with her normal voice. So if she would like to ask to speak, we will hand over to her. Can you hear me now? We can hear you perfectly. If you could just ask to take back the floor, and it's fine now. Francisca, if you could ask to speak. That's okay. Okay, so I have asked to speak, so okay. So I really am sorry for this connection problem. But first of all, before we talk about the problems which I think are often the same, which have already been mentioned by my colleagues and my fellow notaries, I would like to thank and to congratulate all the people who've worked on this project. And in particular, I would really like to thank Christophe, Professor Noissa and Marjorie for this excellent project. Speaking on behalf of the Portuguese notaries, we have taken part extensively, and we would have liked to have even more colleagues with us to take part, and with the other European countries in the project. I'm going to talk to you about the difficulties we have with our notarial instruments in Portugal when we need to indicate matrimonial property regimes, as in Portugal these regimes are declared by the buyers and sellers, and we don't necessarily have to check them, check out any prenuptial agreements or agreements that might be provided. They just declare this. And in many cases, people aren't really sure what their matrimonial property regime is. And the difficulty that we have as notaries in Portugal is knowing the matrimonial property regime they actually are subject to. So then it's difficult to compare this with other European systems. So all the fact sheets that have been prepared during the NBF project, which are excellent, if we could do the same thing for other European countries, without even talking about countries outside Europe where it might be complicated. But this question is one that we're often asked by our colleagues. We do have a lot of difficulty checking these matrimonial property regimes and understanding how they compare with the Portuguese regimes. Another difficulty we have regarding the formal validity of the agreements which the notaries have to apply. So we have to really master all the different regulations of the European Union, not necessarily just the one on matrimonial property regimes, also the other regulations. What I've also heard from colleagues is searching for information on foreign law is very difficult, and we need to find a solution that is suited to this. Perhaps through websites, but it's not easy to get access. The websites that exist aren't always user-friendly, and it would be good if we could have fact sheets. For example, I have a colleague who gave me an idea which I think is interesting, which is that the organizations of notaries could prepare fact sheets which are prepared in their websites so that we can understand the application of these matrimonial property regimes. The other difficulty, I've already mentioned the formal validity of the agreements, and also everything that's already been said about the concerns and difficulties we have in Portugal regard the parallel existence of different regimes. And the choice of law in Portugal is done by an authentic notarial instrument. And I should say that further to the NBF project, which has been very useful for the notaries, it's also obliged the organizations of notaries, and there is the land registry also we work with. And after our training and workshops, that has led us to indicate on our documents now the matrimonial property regime, the effective matrimonial property regime of the persons of other nationalities who are making acquisitions. So we now indicate that in our documents. So this is the sort of problem that's now mandatory. It wasn't before to indicate this information. So the land registry has taken account of that and now requires that we do check the effective matrimonial property regime of people of other nationalities and its equivalence with our own regimes. That can be difficult. Sometimes there are matrimonial regimes which exist in other countries which quite simply do not exist in Portugal, so it's not easy. But that is one of the big difficulties that we do have as notaries here in Portugal. And that's perhaps a more practical aspect. And it is true that the embassies, I know that's not their job, but the embassies or consulates aren't at all prepared, don't have the information on the applicable law or the local law of their different countries or the matrimonial property regimes that exist in their countries. So there is no as there is no convention on the matrimonial property regime. Thank you very much, Francisca, for that presentation of the difficulties. We have almost reached the end of this first panel discussion, and what Francisca said at the end leads us in to the next presentation, which is a presentation of the matrimonial property regime fact sheets. I'd like to thank our different speakers and perhaps to point out that ultimately we all identify the same common difficulties on the basis of these regulations, and perhaps with this common vision of common issues, that's a first step, a necessary first step towards coming up with common good practices, and that's a question we'll come back to later this afternoon. So thank you once again to Francisca, Monique, Hugo and Frédéric, and I'll now hand back to Christophe Pons, who I think is then going to hand over directly to Marjorie de Wiesme. Hello everybody, Marjorie de Wiesme speaking. You can't see me for the moment, you'll see me afterwards. I wanted to begin by presenting the fact sheets that we have prepared on matrimonial systems. As Francesca said, the difficulty here isn't just European, it's worldwide, given the universal dimension of this, which will be the subject of our next panel discussion. But the difficulty resides in the knowledge that the practitioners need to have today of these matrimonial regimes of the different member states and for reinforced cooperation, and also of other states which we call third states, states of the European Union but which are not part of reinforced closer cooperation, and then also third states outside the EU. So the ideal would be to prepare fact sheets on all the different matrimonial systems, especially as Monique said, we have a constraint, Article 25, on the formal requirements, which mentions that when the applicable law to the matrimonial property regime provides for additional rules, they must be complied with. So how can we be aware of these additional rules in addition to what we're used to dealing with, which is the content of the matrimonial property regime, without even bringing up another subject which will be in the report, which is the very notion of matrimonial property regime as established in the European regulation, which is much broader, much more extensive notion than the one we have in national law. So try to facilitate the practice, the work of notaries, we have prepared 6 fact sheets for the partner countries, and this makes us want to create others too. And you have them on the website of NBF Now, the project website, and you also have them on the website of the Notarial Centre for European Law, the ASINODE, which I head, and you will also find them soon on the websites of our partners. If I begin by clicking on the fact sheet for Portugal, you will see that here we have the fact sheets which are designed to be viewed online. We have also made them available to all the participants of our workshops, and they've been a very big success because at our Franco-Portuguese seminar, for example, the Portuguese were interested in having the French and other fact sheets, the fact sheets for the other countries, and our French practitioners had the opportunity to get the fact sheets for the other countries. So these are also very simple to use, to reproduce, and to share in consulates, in seminars, and in training courses with students. And in the rest, if there is follow-up to the project, we hope to continue using these and promoting them. So if I take, therefore, the fact sheet for Portugal, you'll see that we have indicated the primary regime, which that primary regime is one of the questions that we do need to address, because when you read recital 18 in the regulation on matrimonial property regimes, we see that there are rules which cannot be, from which there can be no derogation, and which, so here there would be reference. So there are certain rules which from which the spouses cannot be exempted, taking account of the primary regime. That's why we have included that in the fact sheets, this regime, which is interesting to know, because for the moment that primary regime was not included in this notion, which means that very few studies have been conducted in comparative law on this issue, comparing with different foreign laws, and this is really something that does need doing. Is the primary regime something that we find in all the different legislation of the different countries, as applied to the property of the spouses, or perhaps other areas? But this is a genuine question, a very real question, which requires work in the future for practitioners. And then there's also the question of the legal regime. This is very important. We often have lists in the different journals or in the different sources, sometimes in articles which are produced, where things are simplified. Yes, it's separation or joint ownership of the assets, but even if the names of the regimes may sometimes be the same, obviously we try to simplify to compare, but we have different forms of regime, even if the names are similar. Each country's system works differently to the other. So all these regimes have their specific features, and it is important that we should consult for details, should be familiar with these details, and to understand the difficulty Francesca was mentioning when it comes to the content of this foreign law, we mustn't think in terms of our own national law, which we are familiar with, or our own clauses in our own civil code, and assume that it works the same way that our system does regarding any receivables or debts between the spouses, and then apply ultimately our national rules. So there is no reference to our national law here. We do have to look at the content of the law of the country in question, and that's why we have this explanatory paragraph. Obviously, we have tried to keep these fact sheets simple for use by the general public, but they do have lots of essential, important information which can be very useful if you have a first appointment with clients when you're opening a file, and if you need to look into the details, you have a good basis here. So obviously the official, the legal regime varies from one country to another, and here we describe the nature of the assets, the powers of the spouses, etc., etc., which is all part of this, and how we can share that. Then we have also provided details about the agreements for on these regimes. There are no longer any countries which have a binding mandatory regime, but some of them do, more than others, do have a broader scope in terms of the conventional regimes. So this question has come up several times, and this is a question that often comes up among practitioners. When I designate, choose an applicable law, or when I change it during the marriage, does that oblige me to choose the legal basic regime? That's a question that came up in France for 2 or 3 months. There are lots of contradicting opinions on this regarding the policy, the doctrine on this. And we have a circular now, which is what it is, a ministerial circular of the 24th of April 2019 on applicable law, which states that when we choose an applicable law during the marriage, we can choose any matrimonial property regime accepted by that law, which means that we consider that provided that a law has been chosen, it's then up to the spouses to choose any regime provided by that system. So in our fact sheets, we, after explaining the legal regime and indicating whether there is a primary regime and what is contained within it, we have mentioned this too. So as I said, and what is important, we have proposed a wording on the form of a prenuptial agreement. As we said earlier, that's requires a lot of work, understanding the additional formalities required that might be required of us under Article 25.3 if the spouses should choose a regime or a law that we are not particularly familiar with. In addition to the content of the matrimonial property regime, we have to go and get information as to the additional formal requirements of that law. Is it like in Lithuania where there has to be registration, otherwise it will the prenuptial agreement will not be binding? It's not necessarily easy, and it's different in different countries. So we have also provided a small paragraph on the form of the prenuptial agreement and the provisions. Obviously, this just concerns the domestic law, the national law. We now know that Article 22 of the regulation allows us, when there is a foreign element, to designate a law during the marriage, so to choose the national law or the law of the habitual residence of one or other of the spouses. But each state still has its internal law, and it's important to know whether in that internal law the spouses might find themselves in a purely national internal situation and no longer have the possibility to choose another applicable law than the law of that country. And that's important to indicate, therefore, whether these states do allow this mutability. So I've taken the example of Portugal, but we also have a data sheet on the Netherlands, which I'm just putting up on the screen now, with a new feature, although it's not all that new now, which is that the legal regime was modified there with a transitional regime, a transitional period. So for marriages since the 1st of January 2018, there is a new legal matrimonial property regime and the contractual regime with a community of joint ownership of the property, which is with the possibility of possibility to have separate ownership of assets. So all these different systems which are possible in that country. Also information on the form of prenuptial agreements.
So you also have a document that was prepared concerning Italy, a data sheet, and the legal matrimonial property regime. And often you hear, well, it's the same or almost the same. Community of the community here is almost the same as our community reduced to property acquired after the marriage, the community requests. There are issues in Italian law that we do not have in French law, and this was very well explained by Ugo in our Franco-Italian workshops. They have their own institutions like the Fondo Patrimonio, which is specific to this legislation, which is extremely interesting and which we really need to understand. So, you know, you can't say that it's the same thing, you know, even if we're using the same term. Do not think that the equests regime in one country is the same as in another country. Clearly, through these different data sheets, we have shown the difficulties and the differences, and that Fondo Patrimonio under Italian law is different, and these sheets are summarized, but it gives you some information and it tells you where to go and look if you need to get information. Of course, we have prepared a data sheet on France, which is of interest to our partners, but our French notaries, but also on for foreign notaries. We have the rights of creditors. We have different issues regarding our community of bequests regime. You have a possibility of acquiring for your personal, on your personal behalf, reuse of funds. There are various techniques that can be applied in the community of bequests under French law that you do not necessarily have in other laws. So it's interesting to understand, in particular in terms of acquisition, purchase of real estate property, and this is often used. And it is important to indicate to our fellow notaries throughout Europe that we have these specificities. So for some couples where there is a foreign element, an extraneous element, with a residence in France, they could choose French law as the applicable law because they could use this sort of technique for acquisition purchases. Conventional regimes, change of matrimonial property regimes, all the different provisions are listed in the data sheet. Then we have a data sheet here on Belgium. So the data sheet on Belgium is a community of bequests regime, so community of property acquired after marriage, and it's quite close, you know, between France and Belgium on various aspects, but from a legal viewpoint, well, things are not as close as they seem. We have many differences, and the more you dig, the more you look into Belgian legislation from the French viewpoint, the more you see that really there are some significant differences in practices as well, which are different. The Belgian practitioners implement their prenuptial agreements, their matrimonial advantages, all of that is implemented differently compared to the practitioners under French law, which is the one I know best. So there are specificities related to Belgian law, even though if we often say, oh, you know, Belgian law is like French law is like Belgian law. No, in fact, that's not entirely true. We are close, but at the same time, there are some points that are very far from each other, really. So I really encourage you to look at these data sheets, including the Belgian data sheet. And then to finish, we have the Spanish data sheet. Now, this was not easy. It was not easy to have a summary data sheet on Spain, because Spain, as you know, is a pluri-legislative system. There are autonomous communities which have their own legislation, in particular regarding matrimonial property regimes. And so you already have to understand, and Jose explained to us a great deal and helped us understand regarding the rule of conflicts, regarding pluri-legislative systems, and once we have determined which is the applicable law, which province, which autonomous community we are in, and which law will be identified, then we need to understand the legal regime, bearing in mind that the regime you find in the Spanish Civil Code is not systematically taken up in each of the autonomous communities. Each of them has their own regime. So you have the legal matrimonial property regime in the Spanish Civil Code as it is explained, as you will find it maybe in Madrid. And then you have the Civil Code regimes, and then you have all the information we have in the other data sheets. And in the second part, we have tried to sum up the matrimonial property regimes in Aragon, Catalonia, Galicia, Valencia, so all the different communities that have their specific rules and specific regimes. As we saw with the successions, the matrimonial property regime is the same thing. So here again, we summarized. So if you're really involved in a liquidation, in a case where you really have to go and look into the details of each of these matrimonial property regimes, you will have to look deeper, of course, but at least this will give you some information regarding the content of each of these different matrimonial property regimes. So do not hesitate. Do not hesitate to look at these data sheets. Don't hesitate to refer people to these data sheets, to use them in your training sessions, webinars, colloquiums, and to leave these data sheets, you know, in places you go, you know, the different premises that you may visit. So because they're very easy to use, and we really hope that these tools will be useful. And as Francisca has mentioned, we hope that we will be able to expand on this. Of course, we wanted to multiply them and to do all this research in comparative law, but already those that we have and those that are online, I mean, don't hesitate to make good use of them. Thank you very much. Thank you very much, Marjorie, for your presentation. And you will find all these data sheets on the Notary Beyond Frontiers website. You will find them in French and in the language of the partner country. So now we will take a short digital break to allow each of us to take a few minutes off, and we will come back at 4:10. Don't disconnect. Stay on, stay online, stay with us, leave your computer on, and we'll be back at 4:10 in 13 minutes from now. All right, so let's get started again with our conference, our final conference. So with another round table, which is entitled Applicable Law and Universal Character, What Practices? And I will immediately leave the floor to the moderator, who's Marjorie de Wiesme, who you just heard a few minutes ago on the data sheets, the fact sheets. Thank you, Christophe. So we are starting this second roundtable. We have an article 20 in both regulations, which is similar to the one that we're implying in Regulation 650/2012 on international successions. It's very convenient, in fact, to have you have articles that are actually organized in more or less the same way. It's actually quite convenient. So Article 20 on universal application. It says the law designated as applicable by this regulation shall be applied whether or not it is the law of a member state. This principle, which is the universal application, universality of applicable law, involves a number of difficulties, questions, and in that regard, we wanted to have the opinion, the feedback of practitioners who have worked with us throughout these workshops. I will immediately leave the floor, and please ask me for the floor, Paolo Pasqualis, who is a notary near Venice, and who all of you know those, I think many of you will know, who are involved in international practice. Now over to you, Paolo. Thank you, Marjorie. I hope you can hear me well. If not, please let us know. All right, so thank you for the invitation. Congratulations to the organizers, Christophe, Marjorie, and also to Professor Cyril Nourissa. They are at least the European champions, but maybe even the world champions. And congratulations also to all the speakers in this seminar, not only today, but for the previous events. And I've seen the enthusiasm and also the concrete application, the aspects that have been raised. And thank you to you all. And I'm very pleased to note the success of the seminar. First of all, I should immediately apologize for the fact that I'm going to make my short presentation today in English, because I had notes that I had already written in English, so I wanted to use them today. But of course, I could answer questions in French. All right. So we're going to talk to the issue of applicable, about the issue of applicable.
I would like to recall and underline, first of all, the fundamental principles established by Articles 20 and 21. Article 20 has already been mentioned by Marjorie in the sense of the universal application. And so Article 20 stipulates that the law designated is applicable by as applicable by this regulation shall be applied whether or not it is the law of a member state. And also Article 21 becomes extremely interesting from my point of view, especially vis-à-vis certain legal systems, and is the unity of the applicable law. The law applicable to a matrimonial property regime pursuant to Article 22 or 26 shall apply to all assets falling under that regime, regardless of where the assets are located. These rules were inspired, in my opinion, by the need to provide for the application of a law as possible, as far as possible, strictly connected to the couple, and which provides univocal rules for the entire system of their property relations. regardless, obviously, to the status where the assets are located. Because the European legislator wished to avoid the splitting of different laws and to be, how to say, near to the interest and to the habits of the couple. And in this sense, I would like to underline also the exclusion of renvoi. Article 32 of both regulations excludes the possibility of the applicability of renvoi. The role of universal application, that is to say Article 20, is also useful and opportune from my point of view, because it allows the widest choice of law, and so it privileges the private autonomy, which is normally a good solution in these cases. Of course, as already mentioned today, the principle of universal application, which allows the couple to live according to a law with which they presumably have a close relationship, or with the law most familiar to the couple, can entail, obviously, the inconvenience for the practitioner of having to apply a distant, a far law, and probably also a law difficult to know. Nonetheless, and this is the main point I would like to underline, I consider that these inconveniences may be limited in practice, especially as couples established in our countries will accept the advice to make a choice of law in favor of the local law. In Italy, not only in Italy, in the largest part of the European countries, in all of them, I suppose, are today living citizens of thousands of citizens of different countries who have established their family and working life in our countries, and who would be able to choose the law of the state in which they now live permanently and stably as the applicable law to their matrimonial property regimes or to their registered partnership, of course. As far as the Italian experience is concerned, we do not have many practical experiences, yet we do not have data or statistical data, but the orientation of the Italian notaries in favoring the choice of law by the interested parties is already extremely evident. All the notaries in Italy normally suggest to the couples coming from abroad but destined to live in Italy to choose Italian law. This is mostly because the choice of the applicable law facilitates the security and stability of relationship and also predictability of the solutions, of the results. And obviously, choosing the local law, this facilitates the businesses, bank relations, and if the case, also the solutions in case of divorce. And I dare say that the EU regulations themselves, with their structure and rules, favor and facilitate the solution of the choice of law. They provide a series of clear rules, both to limit the possible choice of law, and this is Article 22, and to establish the requirements of form and material validity of the choice of law, Article 23, already mentioned, and 24. And I, coming to comment, well, the main rules, we already know them, established in Article 22. You can choose the law of the state where the spouses or future spouses, or one of them, is habitually resident in the time the agreement is concluded, or the law of the state of nationality of either spouse or future spouse at the time the agreement is concluded. Let's add that Article 22 of regulation of registered partnership adds another opportunity, another solution, which is the letter C of Article 22. It means the law of the state under whose law the registered partnership was created. This was in order to avoid the case in which the other possible laws would not regulate registered partnerships. And in any case, I would like to say, commenting what was already said today in previous interventions, that also the rules on the former validity of the agreement are good rules, let's say, for the notaries. They were introduced after a strong struggle by the two notaries forming part of the special committee of the experts at the moment of the drafting of the regulation. Because the alternative was that if we accepted only the first part of Article 23, I mean the fact that this choice of law could be just done in written and signed by both spouses. On the other end, this could mean that also a form signed maybe in Las Vegas after marriage celebrated over there could enter as a valid choice of applicable law in our legal systems, in which this normally requires a different solemn official notarial form. So I appreciate the rules of Article 23 in the sense to raise the level of the formal requirements in case of, I would say, in the cases in which this choice of law should be used in one of our countries. And so if you read with attention, let's say, you see how the notaries forming part of that commission have insisted in order to raise the formal requirements to a level acceptable in our Latin, let's say, civil law countries. So please consider that this is not only a concern or a difficulty or a problem today, but is a reasonable solution that we accept in order to recognize in our countries this choice of law. And this is also the case of Italy, for instance, where matrimonial property agreements require the signature of a notarial document, authentic instrument, in the presence of two witnesses. So also the simply, let's say, choice of law in Italy must be done in this specific form. On the other end, I insist once more on the importance of the choice of law. If we just remember on the other end the case of absence of choice of the applicable law, my dear friend and colleague Ugo Friedman has already mentioned how difficult it can be to determine this law when the spouses, they do not choose immediately afterwards the marriage a common habitual residence, which is the time we have to wait until that residence, in the meanwhile, which is the applicable law, and so on. One other important aspect, in my opinion, but I mentioned in a second round table, in the second round of this round table, is the aspects regarding the effects in front of third parties, which is another extremely interesting point from the point of view of practitioners, of notaries above all. And I would like to anticipate they appreciated as well the solutions given by regulation. Thank you very much. Don't know if I have to abandon the floor or you just take it.
Oui, merci.
Yes, thank you, Paolo. We have a short question, but the questions will be discussed after the round table, and then Paolo will be able to give us the answer. Well, thank you for the presentation. Paolo, I agree that most of the time the difficulty will finally be sorted out insofar as many clients will choose the local law, as you said, because they will be better advised by the legal professional they have working with them, and these choices of law have to be made in such a way as to simplify when the marriage regime is liquidated, if the couple separates, or if when one of them passes away. But the practitioner has the obligation to inform the spouses that there is a possibility, because today there are only two options, which is the current residence of one or the other, and the practitioner has the obligation of informing the clients, and not necessarily constantly favor his or her national law. I will now leave the floor to Monique Rambutz to have her views on difficulties on this specific issue. Yes, thank you very much, Marjorie. Just a few short comments regarding Article 26. It seems to me that the objective rules regarding conflicts are not clear in subsection 1. There's very few in the recitals. The first factor of attachment is the first common residence of the spouses. First common habitual residence. This could pose problems to determine applicable law, failing a choice of the parties in the Netherlands, for example. It sometimes happens, and quite often happens, in fact, that the spouses don't necessarily live together immediately after the marriage. Maybe one of the spouses first has to wait to obtain a residence permit, and sometimes that can take more than a year. So can we consider the existence of the first common habitual residence? I'm not sure. Here in the Netherlands, we have a 6-month standard, but what is the viewpoint of the European Court on this topic? To my knowledge, there is not yet any legal decision, case law in the Netherlands, and at the level of the European Court either. So we have the third rule, which is the state with which the spouses jointly have the closest connection. This connection has to be in place at the time of conclusion of the marriage. Subsequent establishment of the matrimonial home does not fall in with this. So, for example, there would not be such a relationship or connection with a holiday state where they do not have much in common. But sometimes it is difficult to determine the state of closest connection, so it could create problems here in the Netherlands, because we have many couples who do not live together at the time of the marriage. So what is the applicable law in these cases? So that is what I wanted to say at this point. Thank you, Monique, for that indication. It is true that there are specificities in the Netherlands, for example, which should be indicated. So we will try to consider that and perhaps provide some solutions or thoughts on this issue because the practitioners in the Netherlands have identified a number of issues there.
So the last presentation on the difficulties we can find here in France now. I'll hand back over to Frédéric Varin, a loyal participant in our NBF workshops. So over to him. Okay. So it's true. I wanted to come back to the application of the regulation and its universality. In fact, we realize that the regulation is intended to have a certain international range and to cover situations, not to cover just situations in countries which are covered by reinforced cooperation. The intention is to do more and that it should apply to states which are not parties to that. And we realize that the regulation by this universal application follows the same line as other European regulations, which also have a universal application, universal scope, and do not just reserve their rules to situations within the European Union. So we hear some criticisms on this subject, notably regarding issues of improving the internal market, things like that. The regulation and its universality is pointed out in Article 20, and we realize that sometimes we'll have a determination of the matrimonial regime which will apply to a situation which is not really closely connected with the states in question. That's not necessarily a difficulty, we just need to make provision for that, and in that case, always, when we do make a choice of law in a prenuptial agreement, for example, or for a change of a matrimonial regime, designating a law, we should always draw the attention of our clients, as Marjorie said, to the effectiveness of the choice that we're going to be making. Among the member states where there is reinforced cooperation, that it is fully effective. But on account of this universality when we make a choice, when the situation is then concerns states which are not part of that cooperation and don't allow a choice of law to be made, even though the regulation makes provision for that universality of these dispositions, we know that in practice we're going to come up against certain limits to this choice of law that we might want to make, no matter what universality is stipulated in the regulation. So in these cases we need to draw the attention of our customers to the need for clauses to take account of the effective nature of any choice of law that we might choose to make. That's what I wanted to say on this subject. Okay, thank you, Frédéric. It's true what you say about that this universality does not mean that we're going to impose our regulation and our texts on the rest of the world. It's a law that can apply in any other state around the world, but we have to take account of the fact that if the couple has assets in certain states, in the state where the choice of law is made, they perhaps need to get information beforehand of how effective that choice of law might be, and we need to inform those clients of the limits there might be to this choice for certain states, because our instrument might turn out to be a bit problematic. There is no worldwide harmonization. There are 18 states with this reinforced cooperation. It's better than nothing. And we can't provide a solution for the whole world, a one-size-fits-all solution for the whole world. So it's quite normal to have something which doesn't apply perfectly internationally. The important thing is to inform our clients so that whatever they choose when they have assets in different countries, that they make a choice of law that is effective, and that there are limits. There might be limits to what they have set up, but this choice of law is applicable, and it is a genuine possibility for any national of the EU, or for the member states of this reinforced cooperation, or for members of nationals of third countries. It's a genuine possibility which is offered to people, and that's obviously a positive thing. We're going to hand over to Paolo Pasqualis, who would like to add something to what has been said. Yeah, thank you. I just wanted to ask you a question about this universality. What alternative could there be for the legislator? Not to make provision for universality and just to maintain the different systems of private international law in the different countries, in which case the regulation would only have applied among the 18 countries which have that reinforced cooperation. So I think that ultimately, once the legislator had decided to create uniform private international law rules for those countries which were interested in taking part in this cooperation, the most logical solution was to say that it wasn't just among those countries which had accepted it, but also in any case, in any private international law system in any country, because I don't see any plausible alternative to that when the legislator was drafting the text. So, sorry for interrupting, but I just wanted to say that. Thank you, Paolo. That's quite true. I think the intention has never been to just set up some rules for Europeans within Europe and restrict it to Europe, or just for nationals of the member states or the countries with reinforced cooperation. I thank you. We're going to close this round table and move straight on now, because that will lead us on to the question that was asked through the chat, and to move straight on to that question in our questions and answer session. So the question comes from the Netherlands, and it was asked to Paolo. So we have a certain number of questions which have come in over the past few days by email as well in the lead up to the conference. When we sent out the invitations, we did give you that possibility of sending us any questions you might have about these European regulations. So there's also the possibility there to ask questions by chat today. So we're going to begin by the first question, which comes from the Netherlands for Paolo Pasqualis, and it concerns the the possibility that in a marriage contract, a prenuptial agreement in Italy, when the registry officer asks whether the spouses want to opt for separate assets under Italian law under Article 162, do you consider that this constitutes a choice of Italian law as the applicable law, if that option is chosen at the moment when the marriage is concluded? In accordance with Italian law, I'm not sure I've entirely understood the question, but under Italian law, as it stands at present, at the moment of the conclusion of the marriage, we can also choose the law. It's not just the option of choosing between the different possible regime under Italian law, which mainly the separation or community ownership, but you can also choose that law which means that in the marriage instrument, that choice of law can be indicated. That's obviously the simplest choice being the choice of Italian law, and choosing a separate ownership of assets. I have only tried to insist on this in 2 cases. In both cases, they were Catholic marriages, and I have not yet succeeded in convincing the spouses at the moment of the conclusion, the celebration of the marriage, to get them to choose the law and also the matrimonial property regime. But it is now possible, and I must emphasize this, either to choose the law or to choose the system for the assets of the spouses. So we're now going to hand over to Hugo, I think, who would like to add something or give an additional opinion on that question. So Hugo Friedman, a notary in Milan. I agree with Paolo. You know, in Italy, we also have publicity of what we have done, whereas in our civil registry, there is the choice we have made, which is recorded and published in the excerpts from the register, and that could serve as publicity of what we have done without requiring a notarial instrument, as is required in most other regimes. That was just to say that I absolutely agree with what Paolo said in his answer there. Thank you, Hugo. So yes, regarding this frequent practice of choosing the law in the prenuptial agreement, so it can be a choice that is made in favor of Italian law, provided that in the couple there is a connection with Italian law under Article 22, because if neither of the spouses has Italian nationality, if neither of the spouses resides in Italy, the choice of Italian law is not going to be possible. So the option is still conditional. There is still that condition that there must be some connection under the terms of Article 22, which must be fulfilled. Otherwise, it's not possible. Okay, so that's for that first question. We're now going to move on. If you would like, please don't hesitate to ask any questions that you might have. Paolo would like to speak. Excuse me, I just wanted to say that obviously, yes, it is essential that we can choose Italian law only provided that the conditions are in place under the terms of the regulation to do so. But I wanted to point out that in the marriage instrument, it's possible not only to choose the matrimonial regime, but also the applicable law. And in addition, in my opinion, the implicit choice of law is not possible. So under the regulation says, I think, about the choice of law, if I can find the text. So dated and signed. So in my opinion, it's not possible that there could be a tacit choice of law, that it actually has to be made in a clear form, and therefore the choice of law, even at the time of the marriage, must be clear. It's not just something that can be done it can't be tacit. Thank you very much, Paolo, for that explanation. We're now going to move on to the second question. So when there is a prenuptial agreement and if several laws could apply with different nationalities of the spouses, would it be possible to choose a matrimonial property regime that's specific to one law and to include matrimonial advantages governed by another law, a different law? So it's true that we have Article 22, which for us in France, unlike the clause here, we have just the residence or the nationality, but it is possible that the spouses might not live together, as Monique said, and as often happens in the Netherlands, or might be of different nationalities. So can we choose several laws? Paolo very rightly pointed out at the beginning of his presentation that Article 21 imposes a unity of the applicable law. That unity is probably the key word here. We can't make a distinction. We can't start dissecting these different regimes. So there are different possibilities which exist, but the future couple, the future spouses, or the couple must come to an agreement and choose a single applicable law. It's not possible to chop things up and to insert clauses as can be done with other European regulations. Here, as for with the successions regulation, we have a single applicable law, unity of the applicable law. So they choose a law, they choose one regime, and they can choose the matrimonial advantages, but all governed by the same law. Okay, so that's question number 2, which was asked. So now I'm going to get Professor Henrissa to do a bit of work, and I'll hand over to him for the third question, which was asked also once again from the Netherlands. I'm just taking a look at the question. Sorry, Paolo would like to step in there. Sorry, this is the last time I'm butting in, don't worry. I don't want to monopolize just regarding the second question. Obviously, I agree entirely that you have to choose one law. But I would say that if that law allows autonomy and to have in a matrimonial agreement certain elements which might be taken from other legal systems, I think you could choose, once the law has been chosen, you could then imagine it might be possible to draft the agreement, an agreement in which you choose certain elements allowed by personal autonomy under the law you have chosen. So choose certain elements, characteristic elements from other legal systems. So it's a rule which is also found in the Italian Civil Code, where it's marked that if we introduce elements provided by a foreign law, they have to be specified. They have to be explained in detail. We can't just refer vaguely to a foreign law. So the Italian Civil Code does allow such an approach in a matrimonial agreement, drawing some elements from different laws. Yeah, thank you, Paolo, for that additional explanation. Now we're going to move on to the third question. So the third question refers to a specific situation, a rather special situation, which can be found in the Netherlands under Dutch law, which allows the transformation of a partnership into a marriage at the registry office. So there could be situations where we have a couple beginning as civil partners in life, and perhaps with age and reason they choose to transform this into a marriage. The question we have is, how do we address the situation where a partnership was perhaps entered into and registered, a registered partnership was perhaps registered in Belgium, or a Pax agreement in France, and that couple then comes to the Netherlands and decides to transform that registered partnership into a matrimonial regime. What is the applicable law there? Are we going to keep the initial property regime, or are we going to switch over to the property regime of the Netherlands, the new property regime of the Netherlands under Dutch law? It's true that the regulation does not make provision for this situation. The regulation does not create this sort of link, this passage from a partnership to marriage. And in my opinion, although perhaps this is open to discussion, it's clear that something which isn't addressed in the regulation can be treated by the private international law rules of the member state in question. Put in other words, in this case, the question of the matrimonial effects of this transformation of a partnership under Belgian law, for example, into a marriage under Dutch law, is a question which will be governed by application, I think, of the private international law of the Netherlands. And we don't have anything in the regulation as a solution for this. So here we see the fact that the regulations are not exhaustive. Not all questions have been dealt with in the regulations. And if I look at the French situation, there's nothing clear on this in the French Civil Code. The French legislature, as far as I know, hasn't made provision for this sort of automatic transformation of a civil partnership into a marriage. All that's mentioned is that if we have a civil partnership, it has to be dissolved before we can marry. And if we're married, we can't enter into a civil partnership. So that points out two things here. First of all, that the private international law of each of the member states continues to have its meaning, to have its scope, and shouldn't be ignored. Harmonization is not total. And secondly, very probably in this sort of situation, you're going to need the wise advice of a local practitioner, a local professional, who will perhaps be able to provide you with the advice you need and to clarify the situation for you. So that's the answer I would provide. I don't know if our speakers would perhaps like to add other things. If Monique perhaps would like to provide more information on this solution.
Also exists in the Netherlands. In the Netherlands, if a partenariat enregistré has been concluded in the Netherlands, it's obvious that it is possible to change it into a marriage, and the same system applies. So if you had a partenaire enregistré with a séparation de biens, the marriage is also with a séparation de biens. If people have concluded a pax in France and they go and live in the Netherlands, the system automatically transforms the pax into a partenaire enregistré with the same rights as a partenaire enregistré that was concluded in Holland. And if this pax is transferred into a partenaire enregistré, and later on the partenaire enregistré is changed into a marriage. Normally speaking, the same system applies. So I'm a bit doubtful whether or not if the pax is séparation de biens in France, then it's a partenaire enregistré in the Netherlands, if it is a séparation de biens, or the legal system in Holland. I'm not so sure. I don't know if there are any Dutch colleagues in the chat who have experience with this situation, because if it was a partenaire enregistré concluded in the Netherlands, I wouldn't have any hesitation, but if it is a partenaire enregistré concluded in let's say France or Belgium, I'm not so sure if it is changed in the legal system or in the system of the foreign country. I don't know if there are any colleagues, Dutch colleagues in the chat who have an answer.
Oui, alors,
Sabine has answered that it was her who asked the question and that there is not, in her opinion, a clear solution to this. But I think what Monique explained very well is that the choice made by the Dutch legislator is to almost nationalize the foreign registered partnership and to make it a registered partnership under Dutch law. If I take the French example, that's not at all the solution which has, for the moment at least, been chosen. The French legislator has discovered that there were other registered partnerships in other countries different to the French PACS system, and has created a special rule of conflict which states that the partnership will be governed by the law of the authority of the place of registration. So in France, you can have the coexistence of partnerships under French law, partnerships under Dutch, Belgian, or any other law. So I think once again that underlines what I was saying earlier, which is that in here, where in the gaps that remain, the things that remain under the jurisdiction of the states. But in any case, it's interesting to note here, and here I'm speaking to our different notaries in our colleagues in the different countries, in Portugal, Spain, Italy, or Belgium. But if they have partnership mechanisms, and if their nationals move to the Netherlands, that can have an impact regarding the possible adaptation of the registered partnership to Dutch law, and perhaps being transformed into the matrimonial property regime. So there we have some very specific features, and personally I think that's a rather good thing, even if it is something of a source of complication, but it shows that the coordination that is there doesn't mean that everything is uniform, that it's one size fits all, and that there is still some room for maneuver. And the solution comes there from the Dutch legislator. Next question: is it possible in a prenuptial agreement to designate the court having jurisdiction in the event of any dispute between the spouses over the matrimonial property regime? Article 7 In Article 7, we have, it is true, that choice of court, which is mentioned. So choosing the courts of a member state. Obviously, the choice is not unlimited. This refers us to the law applicable pursuant to Article 22 or Article 26, so we don't have an unlimited choice. We can choose a court linked to the nationality, the place of residence, or the place where the marriage was concluded. But having said that, we have to be careful here. It would be dangerous to assume or to guarantee to the client that this choice of court will apply in all situations and that it would secure the choice of judge who would be seized with any disputes and the applicable law, because Article 7 straight away begins by establishing limits, except in the cases provided here. So, to simplify, other than in cases where a member state would have jurisdiction to pronounce a divorce or to settle a dispute on succession matters, the choice of courts can be accepted subject to the limits imposed by Article 22 and Article 26, but only outside those cases. And we should be very careful here because it's precisely the main hypotheses where notaries are involved today. Notaries, when there is a dispute and when there is a choice of court, it's generally going to be in the case of a divorce or for settling a succession. There aren't many other situations where this sort of dispute is going to arise. It might be possible with creditors or with a bank, etc. But this shouldn't be this can't be in the case of a divorce or a succession. It would have to be in the professional sphere. What I'm trying to indicate here is that there are limits here. 98% of the cases coming before a notary, in 98% of the cases before a notary, this is going to need explaining to the client, because including this choice of court in a prenuptial agreement means that beforehand you would have to be in a position to give all the warnings and all the advice to the couple, to stipulate the limits that might exist relating to any third states or other member states as regards the effect that we hope to have in this agreement. But we really have to be able to explain to the client that the choice of court that they're going to make has very little chance of being taken into account, because in three-quarters of the time they won't be in a case in which this is admitted. So I think that for practitioners, including this sort of clause ultimately is more dangerous than anything else. The question is, yes, it's possible, but the effect of that clause might be very, very limited. I don't know if you want to add something there. I agree entirely with the warning Marjorie just gave. Very clearly, disputes between spouses or between partners which might come up in these regimes are disputes which are going to be relating either to a case of divorce or to succession, in which there's a dispute, which is to say precisely the cases where this choice of court isn't going to apply, which leaves the other cases. But my question might be for all of us who are listening: have you ever seen, as a notary or as a lawyer, if there are some lawyers out there, had come up against cases of seizing a court? Have you seen cases where a case has been referred to a judge to interpret, to express yourself on the partnership or matrimonial regime. I don't see any situation where this is going to come up. And it's true, the danger here would be to go to see a practitioner or a judge who might not be very familiar with the regulation and who might see this prenuptial agreement or this choice of court or this choice of regime and see this clause and say, okay, no problem. When in fact, so in a divorce, and say, okay, I choose the judge who has been referred to in the agreement. And there we're going to end up exactly with the result we don't want to have, which is that's going to lead to a dispute over jurisdiction. And in the French courts, for example, this sort of dispute will be presented before a judicial court and will take at least 18 months, which means that you've included this clause to avoid a dispute and you're going to end up in a dispute over jurisdiction. So if we really want to have this sort of clause, you have to perhaps almost include the wording of Article 7 and say, except in a case of divorce or of a question of succession or inheritance, the parties agree to choose this law or this court. It's complicated to write, and I'm not sure it's I think there's a fair chance it'll end up being totally counterproductive. So I'm not sure it can be useful to choose a court like this in a prenuptial agreement. So at present you can choose a judge, but not the judge for your divorce. Ultimately, that's what I wanted to say very quickly, but that corresponds exactly to what Marjorie said. And we can perhaps move on to the final question.
Yes, because we're slightly behind schedule. So the last question, when the choice of applicable law is during the marriage, is it possible to make it retroactive to the date of the marriage or to another date? Well, here I will with you take Article 22, unless there is an agreement to the contrary between the spouses. A change of the law applicable will have prospective effect only, and any retroactive change of the applicable law shall not adversely affect the rights of third parties. So two things. As a matter of principle, the applicable law during the marriage, as a matter of principle, has an effect only for the future, but the spouses are entirely free to give this new law a retroactive effect to the date of the marriage or to another date, maybe for professional reasons or other similar reasons. There could be a different date, which is not the date on which the marriage was solemnized. But this retroactive effect must not jeopardize or be detrimental to the rights of third parties. So there is a possibility to have retroactive effect. It's simplest to do that very often to the date of the marriage, because that will avoid then having a succession of different laws that apply. So it's probably easiest to just identify that as from the date of the marriage. But sometimes there is another interest, there is a professional issue. So there is a possibility of retroactive effect. So you have to indicate it very clearly in the agreement, because it will not be done automatically. And then be careful, it must not be jeopardized or be detrimental to the rights of third parties. There you have it. Thank you very much, and we will now move on to the next topic, which is the final report, which is called Conclusions and Recommendations. So these conclusions and recommendations have been presented as a written document. I don't know if it's already available online. I'm told it will be available online soon. And these conclusions and recommendations, well, they are in fact going to guide my talk, because the first point which I would like to focus on, and I've already mentioned this several times, in particular during the roundtable, it's the observation at the end of our different seminars of the reality that there is a common culture of the two regulations which were at the heart of this program. There is in fact a common culture of the regulations, of the questions that arose from these two regulations, and this is not decreed from scratch, as it were, but it is in fact the fruit of time since the entry into force of the regulations, and I would remind you that that was in January 2019. And this common culture, and that's what I'd like to focus on, is nothing without a search for good common practices. And I believe that that is really the heart, the core of the results that we can achieve with the MBF program. And avenues to explore, awareness to be raised, and avenues to explore for good common practice. And this will then lead me to very concretely mention a number of recommendations which I believe can be made, which are recommendations both for the member states and for the European Commission, but also for the profession, and in particular, of course, for the notary profession. Now, regarding the common culture, I believe that it can be very quick, this point, for the notaries who have participated, and Christophe Pons gave us quite significant numbers of participants, people who actually, had a bonus participation. They actually attended several events. So some notaries, came several times, and I think they're fully aware of the text, the letter of the law, the spirit of the law, and the issue of matrimonial property regimes and registered partnerships. And they realized that there was a common structure for the two regulations, and all of this contributes to this common culture with the issue of scopes of application, applicable law, jurisdiction, and many articles are in fact borrowed from one regulation to another without really knowing which is the original regulation, that the leader code or the code that then followed, to take what some legal practitioners say. And we have provisions as well, which are not specific to these regulations, that we find in other European regulations, in particular the regulation on successions. So here we have the factors of this common culture, and this was emphasized by Hugo Friedman in his talk, his comments, and the will to favor a consistency of uniform interpretation. And this is something I would come back to. So a great closeness between the letter and the spirit. And here, and the second roundtable clearly emphasized this. This is perceived today by the notaries throughout Europe. What are the challenges of these instruments, in particular this core challenge, which is autonomy of will? This is central, it's a crucial issue in both, whether it's the applicable law issue or the jurisdiction issue. And when you look at this autonomy of will of the parties is related, or the intention of the parties, which is related to all these matrimonial, it is a legal certainty issue. And And there are complex issues related to that, which each of the speakers has actually emphasized, because you have to have predictability, you have to have legal certainty, and this relates to something that notaries are very much aware of. And there is a major common awareness issue there. So how do these instruments and how do the practitioners work with that to increase the legal certainty? And I think each of us will agree that legal certainty is the DNA of the European notarial practice. Now, as for common practices, I have thought about this and I've identified a certain number. Some are well known and I'll go over them really quickly. Others are perhaps slightly newer, I won't say innovative, but slightly newer at any rate. So just a question of good common practice to emphasize. And the first, and this was mentioned by several practitioners this afternoon, it was a sort of leitmotif of our 10 sessions, which is the issue of qualification. We all know that the legal operation as such is an issue of legal qualification. That is the ultimate legal operation. To define what it is we are talking about, very often there is no clear definition of what we're talking about. These autonomous qualifications, as the Court of Justice of the European Union has put it. And Paolo Pasquale mentioned this here, but also Monique, also Frédéric. It is the issue of the habitual residence. Habitual residence, we know that it is a clear issue relating the spouses or connecting them to a given law. And the choice that was made was a choice to not define what a habitual residence actually is. In the same way as it was not actually defined in the succession law, and we talk about the last habitual residence in that regulation, and in Brussels 2, Brussels 2 bis, Brussels 2 bis recasted, reworded, well, so this allows some flexibility, undeniably, and it can, in practice, it can offer some advantages, but it is also a source of concern. And on that point, I would like to, put these concerns in express them in more relative terms. And I would also like to insist on good practice. So, if we want to speak in more relative terms, there is a way to sort out, to settle the difficulty. And the difficulty is the way to do that is the choice of law. And that will then close the loop, because the intention of the parties will then be clear, and it will make it possible to sort out difficulties related to the issue of determining habitual residence. And for example, to answer the challenge, which is the challenge of characterizing habitual residence, and with a proactive approach, which is very much enjoyed by the European Commission, in the role of notaries to characterize habitual residence. The notary cannot merely content himself with the statements of the parties, of the spouses. The notary, him or herself, has to identify those clues that will allow him to identify where the habitual residence is located. So it's important to emphasize this. And why is that? Well, because this method, and these seminars have shown this, it's perceived differently in the member states and in the notaries of the member states. Imagine that you can see a form of tradition in the practices, in professional practice, with sometimes a national reflex to use. It's an insular reflex. In fact, you take a national practice of the regulations. So in fact, there's a French practice, an Italian practice, a Dutch, Portuguese, Spanish practice. Clearly, that is not the right practice. It's exactly the opposite. Good European practice of the regulation is what we need. And here you have a few avenues we can explore, and they were mentioned throughout the different seminars, and make it possible to understand that it's not just an issue of duration, it's not just an issue of administrative registration in a given commune or municipality as it may exist in a number of states. It is in fact a whole set of clues which will make it possible to establish where the habitual residence is located. And here we have another issue, which is what we call the primary regime, which is these mandatory rules. There is a genuine good practice approach and the need to interpret this autonomously. The matrimonial regime regulation tells us this, and include the rules to which the spouses are bound. And so in good practice, we need to reinforce this raised awareness among practitioners of a genuine common European practice of the regulation. And the second example I could take in terms of good practice, and this was mentioned several times today, it was mentioned by the representatives of the European Commission in the introductory presentation, it's the issue of networking. And that is the very reason the MBF project even existed. It's to contribute to this networking, to cooperation among professionals, and this was mentioned regarding the different matrimonial property regimes. It is clear that a French notary in Bourgoin-Jallieu, in his notary firm, will need the opinion, the enlightened opinion of a fellow notary in Cascais about Portuguese legal issues that will apply. Of course, there are the data sheets that have been drawn up, but the data sheets need to be completed, need to be updated, and we need to continue to work as and cooperate as a network. So, of course, it's necessary to draw up these data sheets, but we have to continue. The issue of developing networks is, of course, an issue. What type of network? In my opinion, my motto is that you can never have too much networking, really. We don't need to necessarily focus on a given type of network. I believe that the fact that a network is effective does not mean that others will not be effective. So we can have public networks, European judicial networks, European notary networks. You can have formal networks, you can have informal networks, purely private networks or purely public networks. I believe the challenge is not so much the creation of a network, but rather a network of networks, which will allow us at the end of the day to be able to contribute to this good practice. Now, some of the good practice, in my opinion, have already come out of this MBF program. I'll just give you one example here. It is the observation, I believe, which is a unanimous observation, I believe, from all the countries represented here, a warm and strong recommendation towards a choice of applicable law to a matrimonial regime, to what we are going to call international couples. I think, I may be wrong, but I think that all the players, stakeholders, all recommend to choose the applicable law, and within that applicable law to choose the regime. Is it the choice of the statutory regime, the legal regime, or is it in a regime that is defined by prenuptial agreement between the spouses? That's on a case-by-case basis, but the idea of choosing the law, whether it's when the marriage is solemnized, during the marriage, I'll take all the different aspects that are described in the regulation. So this choice of law with all the limits that panel number 2 mentioned, or the questions that we addressed with Marjorie a few minutes ago. This choice is indeed the prototype of good practice. I could also give other examples of good practice, but I will refer you to the text of the document in order to stick to the time that was allocated to me. I'll come to one last point, which is the recommendations. Well, you might tell me and say, oh, well, you know, everybody agrees, and so what? What's going to happen now? Well, what else? As we hear in a famous advert, what recommendations, what concrete recommendations can we make? Now, the starting point of these recommendations is a pragmatic approach. Pragmatism, which is related to the fact that during our different seminars, we were not having, you know, esoteric debates on doctrine or other issues, even though we were discussing, you know, fundamental issues. But in fact, we were actually favoring a meeting of practitioners, men and women who on a daily basis concretely have to answer very specific questions that their clients are asking them. And they can't say to the client, oh, well, you know, I'm going to think about this, you know, and we're going to think a little bit longer, and then maybe 6 months, a year, or 10 years from now, we'll see what we can do. So these recommendations are a series of what I call desirable and feasible follow-up from this MBF project. And the first one I would mention is to extend the logic and continue the logic of bilateral seminars. And I attended all the bilateral seminars, and I can say that this logic of bilateral seminars has to continue, has to develop. And to my mind, you know, both between notaries of the member states of the reinforced cooperation, 18, but also with notaries from countries who are not members of the reinforced cooperation, but also in the member states with those who do not know notarial practice. And that is the case in Northern Europe, and they are concerned by reinforced cooperation. So cooperation between member states of the reinforced cooperation. And I must say, at a personal level, the involvement of the closer cooperation, or Portugal, for example, who was not involved in the reinforced or the enhanced cooperation, was a really great surprise, and I really look forward to even more cooperation with Portugal. And I know that there are some very material considerations, in particular the need to think about the notaries in what one might term the new member states. I mean, those who joined as from 2004. Eastern Europe, it would be an excellent way to move forward, you know, to have these this European cooperation with states from the newer member states, in particular from Eastern Europe. The second issue is publication and dissemination of our resources. And what the MBF seminar brought us is the observation, noting that these resources exist, but that many of them are not very well known. So in fact, the MBF site could in fact be the gateway, the portal to these resources. And I'm thinking in particular of the excellent work done by Asinode in this field. And I think that we need to publicize our resources. We mentioned a European notaries directory, and I think that at each seminar we had notaries who were actually discovering the existence of the directory. They didn't know it existed. So that's a pity, but you know, it allowed us to see that you really need to publicize what you're doing and let people know about it. My third recommendation is language, command of languages. And the NBF, there was this scientific content, and there was a lot of networking there, and it showed that it was very important to speak several languages. And I think we can really emphasize the fact, insist of the fact that command of languages is an advantage for some compared to others. And I was just observing with Christophe Pons the admiration we have for Paolo Pasqualis, who speaks English, Italian, French, and he just keeps going, you know, very smoothly from one to another, and that is a huge advantage. And we understand why he's here and why he's present in these institutions. And I believe, therefore, that the linguistic diversity is an issue, and it is a challenge, and you know that the dominant language decided to leave us on the 1st of January. So why should we systematically work only in English? Whereas in fact the major English-speaking country chose to leave the European Union, but that's my personal comment. Fourth proposal related to the observation on good practice is clearly the need for a good practice guide. These guides were actually a habit of the European Union with the first judicial cooperation regulations. This was not done, though, for the succession regulation, for the matrimonial property and property related consequences. So I believe that here we would need a best practice, a good practice or best practice guide, which would allow us to be able to identify issues and to tackle issues such as too much national application or too applications that are too divergent or too different of the regulation. Thinking of the what has been done by ASINODE in this field regarding these guides. And in the logical continuation from the best practice guide, we should in fact as well look at the consequences and of the digital tools that are available to us, of IT. This is at the heart of the concerns of the Commission. The idea here is to think about the creation, in particular based on the practical case studies that have been carried out in the framework of the NBF program, to have a genuine tutorial for the matrimonial property regime regulation and the property consequences of registered partnerships regulation. This would allow couples, professionals, in an approach to see what law they could choose or what law they could not choose, to see what system could apply, as Marjorie was saying earlier, would it be retroactive or not, and with hypertext links, for example, which would then refer the reader to the data sheets, the fact sheets prepared by NBF, or to couples in Europe, or to make it easier to facilitate the perception of the usefulness and the purpose of all of these regulations. I believe that there is not just one tutorial, perhaps two tutorials that could be created, because in fact, and the seminars have shown this, the issue of the matrimonial property regime, like the issue of knowing which is the property consequence for partnerships, raises two questions. The first is the ab initio from the start. Well, our cross-border couple is now being formed, and then you have a question because the couple is going to travel, or because one is French and the other Italian, for example. But it's not the same thing as having to reconstitute, rebuild the matrimonial regime or the property consequence issue afterwards in the case of a succession. And it was shown quite clearly during the first roundtable, where Monique and Frédéric both emphasized the problem of application of the texts in time. And I believe that there are therefore two logics for the tutorial: a sort of general public at large tutorial, which would be accessible through MBF, through the websites of the European Commission, and then a tutorial logic which would be more a support tutorial to support legal professionals, not of course to make a decision instead of the practitioner, because you can never, of course, replace the actual hands-on experience of the legal practitioner, whether it's a notary or lawyer or whatever. But in fact, it would be a decision support to the decision tool. And this type of tutorial is starting to emerge in a number of projects. There was a project regarding Brussels 2B to determine, for example, which judge had jurisdiction in a divorce. And I think that this tutorial approach is, that could be one type of tutorial that could be accessible to all, and another that would be intended for professionals, I think could be very interesting. It could be concrete, practical, and very effective and efficient for the MBF program as a continuation. So in the 30 minutes, that is what I had to say, and that is what I wanted to identify as conclusions and recommendations. Thank you.
Thank you very much, dear Cyril, Professor Nourissa, for those very rich. Thank you, Professor, for those very rich conclusions on the project. And now I would like to call upon Professor Canarsa, Director of the School of Law of Lyon Catholic University, to talk about the Partners Charter and the follow-up to the project. Before that, I would like to inform the participants that there is a short survey we would like you to answer with just 5 very short questions. You will find it on the right of your screen. Top right, you have a small rectangle like a page of paper called polls. If you could click on that and take part in our survey to inform us of your level of satisfaction with today's conference and to know whether the NBF project met your expectations. So please fill that out before you head off at the end of the conference. So now I hand over to Marjorie, Cyril and Marjorie to present the Partners Charter and to consider the future for this project. Thank you, Christophe. In the initial application, there was a question about the sustainability, the longer term future of the project. And we gave a commitment to, at the end of the project, to draft a charter for continuing the partnership. That's what we're going to talk about in just a few seconds with Marjorie and Francisca, if she's still there. It was starting out from a very simple starting point, which was that the content of the project and the different deliverables mentioned in the course of the afternoon, the many deliverables, the fact sheets on the different matrimonial property regime, the national fact sheets, which are now which now provides an initial approach to the content regarding a certain number of member states. There are the practical cases you have, which were discussed during the different workshops in detail, which are now available. And then there is the network that Professor Nourissa mentioned, with the many notaries who have taken part in the different workshops. And so that is a very rich starting point, which allows us to look to the future of our cooperation. So we thought of a number of different possible avenues which seemed quite natural to us and which would enable us to build on what has been done in this project, the things I've just mentioned, and also to pursue the construction of a network, building on the existing network among the partners in the project, and to carry on working on the questions of common qualifications for the different notions referred to in the regulations. So a lot remains to be done, as we have already said. So I think on a scale for the medium to the long term, building on that initial conviction, that initial commitment through these formal and informal activities, that's how we can shape the judicial area of the European Union relating to these texts. I think that there are several points need to be made here. We have developed a certain number of resources over the past couple of years, the fact sheets, which are very useful, very important, I think. And as Cyril said in the report, we have already quite a lot of tools. We have websites, we have tutorials, we have all sorts of things. There's still more to be developed, but we absolutely must communicate about these tools and make sure that they are used. We've given a commitment to keep them on our websites for several months or even years. We need to make sure they have a life, not just for the practitioners. That's what we have been doing during our workshops, addressing mainly notaries and professionals. But I think what we also need to do is to promote them in initial training of students, and we're here in a university, so it's the perfect place for our students. Very often what is missing for students, there is the mastery of the language, there's the familiarity with this private international law, with these European regulations. This is something we need to foster from the beginning. We have developed tools, and the students we're going to be meeting in our different courses need to be familiar with these tools, need to learn to work with them, to make the most of them, to profit from what we have made. We can refer to them in our classes or use them in our examinations. So I think we need to encourage students from the beginning to make use of everything that has been created. And I think that is an important point, to have the students benefit from this. Also, in terms of contacts, we've been developing the network for the professionals. We've said since the beginning of this afternoon that it's important for us to work together to resolve international cases, to provide responses to our clients, our international clients. But why not also all work together with these students, with trainees, with all the possibilities that can open up for them, the possibility to go off perhaps to do internships more often during their notarial studies through our networks, through our contacts that we have established through NBF, and to have them travel if the health situation does allow them to travel soon, because that obviously also, but that's also what's important here, to reach out, to go further. And I also see that as a follow-up to NBF. We've addressed the practitioners, that's all very well, we've created a certain number of things. We need to promote everything we have already created, everything we already had, and now extend that more broadly to other audiences. It's true that among the points that are to be mentioned, there is this inclusion of these materials in initial training for students, because that is how we are going to elicit an interest among students students who may be thinking about becoming notaries. Very often they have a vision which is very much national or even local of their profession, and perhaps underestimate the international dimension, the growing international dimension of the notarial profession. And from a generational point of view, we know that there are increasing numbers of cases each year for successions and other things with an international element. Also, all the binational couples, which are becoming increasingly frequent and are a part now of the day-to-day practice of notaries. And I think that is perhaps partly our fault, but our students perhaps underestimate this international dimension. And the European programs, and in particular Erasmus Plus, can be of interest, I think, in this respect in terms of cooperation. They fund not only stays for studies, but also internships. And if we're going to make the most of the network that now exists and extend that network, we could propose internships to students for 1 month, for 2 months, perhaps more, funded by the European Union in the member states, working in notarial offices. And that could be a way of building for the future, building something concrete, practical, tangible for the future. And that's one of the things that we could implement. We do try to encourage our students to look for this sort of internship. Often it's quite complicated because they don't have the contacts there, the international contacts. And this is something that could perhaps be done to familiarize them with these international dimensions, build a network, and that's where programs like NBF can be useful in preparing these notaries of the future and increasing their awareness of these international and European dimensions, with all the opportunities that they bring. So perhaps it may be possible to be a notary without an immense understanding of private international law and other things. But when you do have that mastery of those international aspects, there are more opportunities for you professionally. And that's what we're trying to provide to the students, a range of opportunities, a much broader range of opportunities than what they might have in other circumstances. And I think we could also think of one-off training courses for young notaries, for student notaries, trainee notaries. That's also something which is mentioned in the Charter. It's a suggestion made by the Organization of Notaries, the Order of Notaries of Portugal. I don't know if Francisca is still with us, but that is something that has been presented as a possibility, and perhaps Francisca is there, so if she would like to speak on this subject. Just to say, I am still here, yes, so to sign the Charter with great pleasure on my part. Thank you, Francisca. So we mentioned that idea that you put forward to consider occasional short training courses on the matrimonial property regime and registered partnership regulations, and perhaps the other regulations of the European Union in civil and family matters, which could be considered with the expertise of the Notarial Centre for European Law and the network we have formed. So as regards Lyon Catholic University, the rector will be signing the charter very soon, and our president also. And so over the coming 2 years, it's up to us to work hard at this and perhaps identify other large-scale projects within the framework of the Justice Programme of the European Commission. And in any case, it would be a great pleasure to do so. There is still a lot to be done. I think you have contributed hugely to getting things moving, and we can now move forward. Thank you very much, Marjorie, Michel, Francisca, for that information and for that look to the future of the NBF project, a magnificent future, I'm sure. Please bear in mind, in the survey, the responses were very strongly in favour of continuing with the project. We're now going to move on to the conclusion of this final conference of the NBF project, which ends on the 31st of March. But today is the last public event for the project, and it's our dear director of the Faculty of Law, the Law School of Lyon Catholic University, who is going to conclude the afternoon's proceedings. A conclusion and thanks, I should say, after an afternoon which has been very rich. My thanks as we reach the end of the afternoon and the project go to the main actors in the project, which has kept us, or kept you, busy for more than 2 years. The initial duration of the project was 24 months. The health crisis changed that duration slightly and extended it by 6 months. Obviously, between the beginning of the project, the kick-off meeting in Lisbon, the first workshop here in Lyon, and this workshop and this closing conference, things have developed, things have changed. I think the enthusiasm has not waned at all. Very much thanks to the tenacity of the actors in the project. First of all, Christophe Pons, the coordinator of the project, my colleague, without whom the different activities would not, I think, have gone as smoothly as they did and might not have taken place at all. Obviously, the health crisis brought some major adjustments, but I'd like to thank him here officially and publicly and sincerely for all the energy that he has put in unstintingly into the project. The two other main actors in the project have spoken this afternoon and have been present at all the workshops. Marjorie de Wiesme, director of the Notarial Centre for European Law, one of the other partners in the project, main partners in the project. Once again, without whom the application for the project would not have been submitted. The workshops would never have taken place, at least not in those conditions. Professor Cyril Nourissa, who worked in partnership with Marjorie throughout the workshops. With both of them, thanks to their networks, thanks to their knowledge, and thanks to their conviction as well, have made it possible to achieve these results, which are very positive. Also, the Order of Notaries of Portugal, the third main partner in the project, which made a massive contribution, in particular in terms of the participation at the workshops in Portugal with the Portuguese notaries, and also the associate partners, the Order of Notaries of Milan, the International Council of Belgian Notaries, the Royal Dutch Association of Civil Law Notaries, and the Spanish College of Notaries. The other deliverables are the visible part of the iceberg of everything that has been done, all the work that has been put in, with a lot of activities, less visible activities. It's a project which, like others, has involved a significant number of participants in the different organizations, and notably here at the Lyon Catholic University, also our communication department, I would like to thank, who were a central player in the different events and occasions that were organized. We hope that we have made a modest contribution to the effective application of the regulations on matrimonial property regimes and registered partnerships. I am convinced that this is a long-term effort that is to be made in this area of European law and private international law. This requires us to adopt not only rules and to apply them, but also to create a certain number of less tangible conditions. We need that networking, we need to use languages, we need to be aware of the importance of these questions. And as I said earlier, in terms of generation, there are challenges which are growing within the European Union because of the international situation, particularly in the European Union for European Union nationals, which are going to be increasingly frequent, and the legal experts know and notaries know that these situations generate complexities which perhaps people were not familiar with until recently. And to manage that complexity, we need to train, to get initial training and lifelong learning also. That was the role of the NBF project, Notaries Beyond Frontiers project, and that we have been delighted and proud to coordinate over the last 30 months and up to the end of the month. So thank you very much to all of you. Thank you to all the notaries who have taken part in the different workshops, sometimes, in some cases, several times. And thank you also for the co-funding of the European Commission, without which these activities would never have taken place. And I hope you have an enjoyable end to the day in your respective member states from which you're watching us, and we hope to see you all again soon, hopefully present in person. And see you soon.